paper. Orders of the day.
Private members' business, second reading of Bill C-375 in the name of Mr. Jowhari, an act to amend the Criminal Code, pre-sentence report.
Mr. Jowhari, seconded by Ms. Khalid, moves that Bill C-375, an act to amend the Criminal Code, pre-sentence report, be now read a second time and referred to the Standing Committee on Justice and Human Rights. Debate, the Honourable Member for Richmond Hill.
Thank you, Mr. Speaker. Mr. Speaker, it's an honor for me to rise today to address this House for a second time to talk about my private member's bill, Bill C-375, an act to amend the Criminal Code with respect to pre-sentencing reports. I would like to thank my honourable colleague and a friend, the member from Mississauga Erin Mills, for seconding this bill today. Mr. Speaker, I'd like to reflect at the outset of my statements on the great honor and the privilege I possess as a representative of my constituents in Richmond Hill. This is an honor that no member in this House take lightly, and I'd like to my colleagues, I am aware of the great responsibility that comes with representing one's constituents in this House. I came to Ottawa, Mr. Speaker, having made the commitment to my constituents in Richmond Hill that I would focus all my energies on advancing the progressive ideals that I was elected to uphold and fight for, namely the advancement of equality for all Canadians, in particular with those who feel voiceless and marginalized. When it comes to the subject of mental health, we are all aware of the great sensitivity involved with addressing the challenges of this often marginalized group. It is perhaps this very reason that we must do everything we can to ensure that no stone is left unturned in safeguarding the rights and dignity of those suffering from mental illness. This is a goal I've committed myself to working towards actively and with great care. Through my work as founder and co-chair of the All-Party Mental Health Caucus, I, along with other participating members, heard from numerous stakeholders and experts involved in the field of mental health. I know I can speak for all members who participated when I convey how eye-opening the testimony we heard was. What we heard pointed a picture of current mental health landscape that is rife with gaps and areas of improvement. In particular, issues related to mental health and criminal justice system came to the forefront as needing special attention. To obtain a better understanding of the current issues surrounding the treatment of individuals with mental illness, caucus members visited Kitchener, Ontario, where we received a tour of Grand Valley Institute for Women operated by Correctional Services Canada and heard from Ms. Sherry Payne, herself a formerly incarcerated woman, who informed us of the various challenges faced by the correctional system when it comes to mental illness. Our experience in working with Mental Health Caucus led to our resolve that many operational and legislative changes are still needed to improve the delivery of the service to mental health sufferers, in particular those in our criminal and correctional systems. Section 2 of the Criminal Code defines mental disorder as a disease of mind. Unlike disease of the body, the symptoms that mental illness carries are very often hidden and difficult to diagnose. In too many instances, while mental illness is also misdiagnosed or ignored entirely. In Canada, 10% of the population reports symptoms consistent with mental illness. This burden, sadly, is often greater on our youth, fully 25% of whom will experience a mental health issue as they navigate to adulthood. In our federal penitentiaries, this proportion is even higher. Over 20% of federal offenders are identified as presenting mental health problems, often with more than one disorder. Furthermore, rates of mental illness among federal offenders have almost doubled in the last 20 years. Globally, the World Health Organization reports that by the year 2020, mental and behavioral disorder will account for roughly 15% of the global burden of the disease, which it projects further is likely to increase in proportion in subsequent decades. Even with respect to our attitude to mental illness, there is still work to be done. While half of Canadians reported in 2017 that they are more comfortable talking about mental health than the last 5 years before that, it is also reported that this has not led to an adequate and proportionate growth in community resources for those suffering from mental illness. For individuals suffering from mental illness, then, theirs is often a daily struggle to integrate into families, peer groups, and society as a whole. These same families and peer groups bear an untold burden, both emotional and economical, that must be addressed. It is estimated that the total cost of mental health problems to the Canadian economy exceed $50 billion annually in healthcare expenses and lost productivity. This represents nearly $1,400 for every Canadian. Mr. Speaker, over the next 30 years, this cost will add up to more than $2.5 trillion for the Canadian economy. We all must therefore recognize mental illness as an issue that affects not only the present circumstances of Canadian families, but their future as well. And I'm happy to be able to say that our government announced in Budget 2017 that it will invest $5 billion over 10 years to improve mental health services, with an addition of $118.2 million to address mental health programming among First Nation and Inuit peoples. This bill, C-375, is also inspired by another idea. Mr. Speaker, we believe that better is always possible. Bill C-375 will amend paragraph 721(3)(a) of the Criminal Code such that, unless specified, when a pre-sentencing report is required by a court, in addition to such information as age, maturity, character, behavior, and attitude, information outlining any mental health disorder, as well as any mental health care programs available for the accused, be provided as part of their pre-sentencing report. I would like to take this opportunity to outline in detail why my colleagues in this House must support this essential bill to address mental health concern in our criminal justice system. Currently, courts are not mandated to consider the mental health history of individuals in pre-sentencing proceedings. This significantly increases the likelihood that such vital information will not be taken into account during pre-sentencing, and that individuals with histories of mental health issues may not be afforded appropriate care, compassion, and treatment throughout the process of their rehabilitation. Mr. Speaker, what are the real-world consequences of this status quo? Mr. Speaker, pre-sentencing reports are a vital tool at the judge's disposal. 87% of the judges see pre-sentencing reports as important in giving much-needed analysis and advice on offenders' treatment needs. By and large, when a pre-sentencing report is present in a case, there is significantly higher likelihood that an offender will receive a community sentence as opposed to a custodial sentence. By stating plainly and unambiguously that mental health background and treatments option must be included in pre-sentencing report along with other background information, probation officers who are tasked with preparing these reports will have to work from a clear standard whereby the investigation of an offender's mental health background will be deemed at least as equal to other factors. Underlining this framework will be the ideal that such individuals with histories of mental illness are best approached for the model of what Justice Richard Schneider terms therapeutical jurisprudence. This is in contrast to traditional punitive approaches seeks as a primary goal to limit offender recidivism with the court. Thus, this bill, in many ways, takes one further step towards the deinstitutionalization of mental health and one further step away from when mental health sufferers were subjected to mandatory and undignified confinement. Across Canada, individuals with mental illness find themselves involved in the criminal justice system under circumstances that are tragic and horrific, both for themselves and their victims. Many of the experts and advocates who I have spoken to on this subject agree that it requires a host of policy approaches to address. Bill C-375 is just one such approach to addressing mental health and criminal justice system. As a modest and uncontroversial step in the right direction, I extend my hand to all members from each caucus to work together with me on this important initiative. In closing, Mr. Speaker, I'm confident that with this small yet significant change to our criminal code, all members in this House will do their part in ensuring that those suffering from mental illness will be afforded the compassion and care they need and they deserve. Thank you, Mr. Speaker.
Questions and comments? Question commentaire. The honourable member for South Okanagan, West Kootenay.
Well, thank you, Mr. Speaker, and I'd like to thank the member for his speech in presenting his bill. And I just wondered if he could expand perhaps on what his government is doing, what steps they're proposing to help people with mental illness stay out of the criminal system, and what steps they might be doing to help them move back into society, the real supports that these people need, that we need to support people with mental illness, treat it as a health issue, and help them stay out of the criminal courts and get back into society as well. Thank you.
The honourable member for Richmond Hill.
Mr. Speaker, I thank the honourable member for his question. Our government has been proactive on this matter, and the first step that the government took was introducing, in our budget 2017, $5 billion over 10 years. And our government is working very closely with all the provinces and territories to ensure that that funds are properly allocated and it focuses on the services that are needed. Our government is also working collaboratively with provinces and territories to make sure that there are proper indicators and proper metrics are developed that they could be reported on collaboratively with the provinces and territories. As to the fact of what's being done at the correctional services, as I said in my speech, Mr. Speaker, I had the opportunity with some of my colleagues to visit a number of correctional services, specifically the one I mentioned, as well as the one for youths which are sentenced under 2 years. And I saw firsthand the support that's given to the youths when in the process of their incarceration to be able to get rehabilitated. Unfortunately, because there is no consistency in our court during the pre-sentencing report that those services are highlighted and emphasized, it's case by case. We are fortunate that in the instance that I had the opportunity to visit the correctional services, most of the youth had individually identified their needs, and those were taken into account. With this bill, I'm hoping with the support of colleagues across the aisle and my colleagues from my caucus, for us to be able to make it mandatory for those services to be highlighted as part of the pre-sentence report, so those services will be considered to make sure that they're available for the member, for the individual that's going to be incarcerated. Thank you.
Questions and comments? The honourable member for Mississauga, Aaron Mills.
Thank you, Mr. Speaker, and I really commend my colleague for his great initiative, not just in presenting this private member's bill, but also in his very effective advocacy with respect to mental illness in his work in in the All-Party Mental Health Caucus. My question to the member is to basically understand what kind of feedback he's received from stakeholders from across the country with respect to his private member's bill and whether they're in support of it. Thank you.
The honourable member for Richmond Hill.
Thank you, Mr. Speaker, and I thank my colleague once again for asking a great question and also once again seconding the bill today. This bill was inspired by my discussion with many experts and advocates in the mental health field. I met with many stakeholders through my work on Mental Health Caucus, as well as independently. We got a chance to get an overview of the gaps that's existing in the current system and how the shortcoming will be addressed. Notably, I would like to point out that this bill has support among the Canadian Bar Association, as well as many experts I've met with who deal with mental health on a day-to-day basis, such as clinical psychologists, correctional staff, and nurses have also expressed their desire to see changes in this bill. So, Mr. Speaker, I would like to say that there is a broad consent around the fact that we need to address this issue among many other issues. But this is an issue that's within the jurisdiction of the federal government, and this is something that we need to make sure we address to ensure those who are incarcerated during their incarceration process, they are afforded the programs to be able to make sure that they get integrated back into the community when their terms are over. Thank you, Mr. Speaker.
Resuming debate, the honourable member for St. Albert, Edmonton.
Thank you, Mr. Speaker. I'm very pleased to rise to speak on Bill C-375, introduced by the honourable member for Richmond Hill, an act to amend the Criminal Code. More specifically, Bill C-375 seeks to amend Section 721 of the Criminal Code. Section 721 deals with pre-sentence reports, and what Bill C-375 would do is amend Section 721 to require that probation officers always, consistently in every pre-sentence report on any mental health disorder of an offender, as well as report on programs and services related to mental health available to the offender. Let me say at the outset, Mr. Speaker, that there is no question that mental health is a serious issue in Canada's criminal justice system. We know that the percentage of individuals in prison who have mental health issues or addiction issues is very large. Indeed, according to the latest report from the Correctional Investigator of Canada, more than half of the female prison population has some mental health issue, and 26% of the male prison population has a mental health issue. So when we're talking about the criminal justice system, when we're talking about prisons and issues around mental health, we are talking about a very significant percentage of the prison population. And there's no doubt, and a lot of attention has been placed around issues around mental health in prisons as a result of some recent highly publicized incidents involving prisoners with mental health issues and how they were treated. And there's no question that there is plenty of work to do to ensure that the health and safety of prisoners with mental health issues who are behind bars are protected. And to that end, Parliament has a responsibility and a duty to act to ensure that those issues are addressed and to deal with shortcomings in terms of the federal prison system when dealing with persons with mental health issues. Now, with that said, Mr. Speaker, Bill C-375 specifically deals with pre-sentence reports. And I guess by way of background, each and every year in Canada there are thousands of pre-sentence reports that are prepared. Pre-sentence reports are not mandatory. They are prepared at the request of a judge who may need the report or look forward to the report to obtain additional information and background about the offender in order to craft an appropriate sentence for the offender. Now, Mr. Speaker, Section 721 of the Criminal Code provides that certain information must always be included in pre-sentence reports. Additionally, Section 721 sub 2 of the Criminal Code provides that provinces may, by regulation, require additional information be included in pre-sentence reports in their respective provinces. Additionally, Mr. Speaker, judges have the discretion to request that certain issues or certain matters are addressed in a pre-sentence report where the judge deems it appropriate, having regard for the unique circumstances of each individual offender. So the reality, Mr. Speaker, taken together is that when we're talking about issues around mental health that may concern an offender, when we're talking about issues around programs and services related to mental health in respect of offenders, the fact is that today that information, those issues can be addressed, can be investigated, and can be put forward in a pre-sentence report. And indeed, it is not uncommon, depending again upon the specific circumstances of each individual case and each individual offender, for judges to make that request and for judges to take those matters into consideration. And so, while I appreciate that Bill C-375 is a well-intentioned bill, and while I know that the honourable member for Richmond Hill has been a strong and passionate advocate around issues concerning mental health and vulnerable persons in Canadian society, I believe that Bill C-375 is unnecessary. Moreover, Mr. Speaker, I believe that in addition to being unnecessary, Bill C-375 has the potential to create confusion and result in unfairness and inconsistencies in the administration of justice. To that end, Mr. Speaker, there is a considerable variance in terms of the behaviors and conditions that fall under the umbrella of mental illness. The fact is that not all mental illnesses and mental disorders are the same. They, even within some disorders, the degree of impact can vary considerably. And in addition to that, Mr. Speaker, there is a real potential that the effect of Bill C-375 could cause delay and backlog, further backlog, in our criminal justice system, which is already backlogged. Further, Mr. Speaker, Bill C-375 will significantly increase the amount of work that a probation officer undertakes in preparing a pre-sentence report. That additional work may be necessary in many cases. But again, that is already done in those cases, because by the time that a verdict is rendered and a judge gets to the sentencing part of a specific case, issues around mental health, where it concerns the offender, are almost certainly have been brought forward to the attention of the trial judge. And so rather than taking a one-size-fits-all approach that can create inconsistencies, that can lead to confusion, that can result in backlog, that can slow down the administration of justice, Mr. Speaker, I would submit that the best approach is to do what is taking place, and that is to leave it to the discretion of trial judges. Thank you, Mr. Speaker.
Reprise de débat. La députée de Hochelaga.
The Honourable Member for Hochelaga. Thank you, Mr. Speaker. Thank you for giving me the opportunity to speak today to Bill C-375 from my colleague for Richmond Hill, which amends the Criminal Code. This bill has a single clause, and its objective is to provide more information on the accused's profile during the pre-sentence report, which will be used by the judge to determine the most appropriate sentence under the circumstances or decide if the accused should be absolved of any sentence. During the first reading of this bill by its sponsor, the member for Richmond Hill indicated that according to the bill, when a court requests a pre-sentence report, other than information such as age, maturity, character, behavior, attitude, and willingness to rehabilitate, this report should include the mental health difficulties that the delinquent may suffer from, as well as programs that could offer care. It is essential that this information be provided so that Canadians who have mental health issues may be able to be cared for with compassion and receive the treatment that they need throughout their entire rehabilitation. Bill C-375 indicates that subsection 721(3) of the Criminal Code is amended by adding the following after paragraph A. A1. Any mental disorder from which the offender suffers, as well as any mental health care programs available to them. The pre-sentence report is distributed to people who have a direct interest in the matter, namely judges, lawyers for the defense, the Crown attorneys, parole officers, the individual of the report, targeted by the report rather, or the facility where the sentence will be served. This report is specifically or rather especially used by the judge in order to allow them to determine the appropriate sentence and to inform the accused of services available that could be necessary to rehabilitate them. The New Democratic Party is determined to build a criminal justice system that works and to make sure that compassion and rehabilitation are at the heart of our policy. Asking for information regarding an individual's mental health to allow the judge to make a more informed decision on the appropriate sentence is directly in line with the idea of a justice system based on rehabilitation, such as including information on available mental health programs and services. The objective is not to reveal the mental condition of an individual or to perpetuate stigmatization or the false perception that people who have mental health problems are dangerous. The objective of this bill is to add information to the pre-sentence report in order to develop it to help the individual to receive an appropriate sentence and, with proposed amendments, to receive the services that they require. People who have mental health problems are overrepresented in the Canadian criminal justice system. Documenting the number of people found guilty of specific crimes who also have mental health problems would contribute to demonstrating the needs for programs and alternative solutions. This information could also be used to develop resources and initiatives that would prevent people suffering from mental health problems from being caught up in the criminal justice system in the first place. Although the legislation regarding pre-sentence reports, namely the Criminal Code, is a federal law, it's administered by provinces and territories. And provinces and territories do include different information in their pre-sentence reports. Some provinces, such as Nova Scotia, already recommend that mental health problems be disclosed, but that's not the case for all jurisdictions. This bill would create a national standard for all jurisdictions in order to take into account an individual's mental health when deciding on the sentence. Bill C-375 would require that the report contain information on mental health care programs that could be made available to the individual with the intent to rehabilitate. A study by the John Howard Society of Ontario reported in 2015, and I quote, and what I'm reading is a translation, since the closure of institutions serving individuals with mental illness and developmental disabilities, the criminal justice system has become a repository for individuals who lack adequate resources to cope with living in the community.
An annual report of the Correctional Investigator in 2012 showed that 36% of inmates in federal institutions were in need of psychological or psychiatric follow-up. Furthermore, 45% of male inmates and 69% of female inmates had received mental health services in their correctional institution. Young adults between the ages of 18 to 34-year-olds are overrepresented in correctional institutions, yet they only represent 28% of the Canadian adult population, according to 2015-2016 Statistics Canada data. An Ontario study also showed that 80% of young adults in custody have one mental health problem or another. In 2015-2016, Indigenous adults were also overrepresented in provincial and territorial correctional institutions. They represented 26% of the intakes, whereas they only represent 3% of the Canadian adult population. The overrepresentation of Indigenous adults was more pronounced amongst women than amongst men. Female Indigenous individuals represented 38% of women taken into custody after conviction in provinces and territories, whereas that number for men was 26%. In federal correctional services, Indigenous women represent 31% of women in detention after conviction or in custody after conviction, whereas males represent 23%. Mr. Speaker, there is a problem when someone is sent to prison with mental health issues and is not offered appropriate services. In last April, the Toronto Star reported this from Judge David Paciocco from the Court of Appeal of Ontario, and I quote,
"Execution, conviction, sentencing, use of segregation, all stages of our criminal justice system are now consistently overrepresented by people who are suffering from psychosis, mania, mood disorders, depression, alcoholism and addiction, anxiety disorders, and personality disorders."
And the judge continues on to say,
suffering from mental health issues who are swallowed up by the criminal justice system do not fare well. The use of segregation or other standard isolation practices are the clearest example of a system whose practices rooted in punishment and control can exacerbate the challenges facing people with mental health issues. Individuals leaving the system can leave with unmanaged or worsened mental health issues, which can contribute to recidivism.
And that's exactly what we want to avoid. The New Democratic Party is committed to collaborating with community stakeholders, mental health professionals, frontline workers like the RCMP, and provincial and territorial justice systems in order to obtain better support services for those individuals suffering from mental illness. We also want to make sure that communities have the necessary, as I was saying, resources and services to help those suffering from a mental illness before and during their integration into the correctional system. We must continue to focus on compassionate care that helps people suffering from a mental illness to reintegrate into society after their incarceration and avoid to the greatest extent possible excessive criminalization. Mr. Speaker, the more we are able to assess the needs of individuals who are given a prison sentence, the more our justice system will be able to refocus on appropriate rehabilitation services and thus, in the best case scenario, eliminate the risk of reoffending. That is one of the reasons why the New Democratic Party wants pre-sentence reports to be more comprehensive, and that is why we will support this bill. A mental health illness can have an important impact on the life of an individual. The disclosure of mental health problems should be taken into account in choosing an appropriate sentence and a rehabilitation plan. Rather than engage in tough-on-crime rhetoric, the New Democrat Party has always focused on taking the necessary steps so that our justice system will actually work. Our goal is to help those found guilty who are suffering from mental health problems to be able to benefit from the necessary support and resources so that they can be rehabilitated and become full-fledged members of our society. We believe that it is important to offer all possible support services and resources to those suffering from mental health issues who are in the justice system. Thank you once again for allowing me to speak to this bill, Mr. Speaker.
Resuming debate, the Honourable Member for St. Catharines.
Thank you very much, Mr. Speaker, and it's good to see you in the chair, Mr. Speaker. I hope you're enjoying your role as the neutral arbiter of this debate. It's good to see you in that role. Mr. Speaker, it's my pleasure to stand today and join in on the second reading debate on Private Members Bill C-375, an act to amend the Criminal Code. And before I begin my speech, I'd like to thank my honourable friend from Richmond Hill, who in caucus and throughout this Parliament has been a tireless advocate for mental health. This bill would amend provisions of the Criminal Code dealing with pre-sentence reports to be more responsive to offenders with mental health issues. A pre-sentence report is ordered in some cases to help the court learn more about the person being sentenced. Specifically, this bill would amend subsection 721(3) of the Criminal Code to provide that a pre-sentence report must, where available, and unless the court orders otherwise, contain information on any mental disorder from which the offender suffers, as well as any mental health care programs available to them. Requiring information about the offender's mental health disorder would be in addition to the information that the Criminal Code currently requires to be included in a pre-sentence report. Under the current law, a pre-sentence report must, wherever possible, contain certain information about the offender, such as age, maturity, character, and willingness to make amends. Bill C-375 would make it clear to the courts that where mental health information is readily available, it should be included in the pre-sentence report. For example, often an offender will provide information about their mental health situation to the probation officer who is preparing the report. The officer will often include this information in the report, which is in turn relied upon by the Crown, Defence Counsel, and the sentencing judge. The sponsor of the bill, the Honourable Member from Richmond Hill, has indicated that his intention of introducing this bill was to ensure that information outlining any mental health disorders, as well as any mental health care programs available, is before the court, to ensure that those offenders with histories of mental illness are afforded care and compassion, and they will receive appropriate treatment throughout the process of their rehabilitation. Mr. Speaker, I agree with the sponsor that this is an important information that can be extremely valuable to a sentencing judge. In fact, it's my understanding that criminal courts in Canada can and do consider the mental health information of offender when it's before them. Any sentence that is imposed without reference to available medical evidence, including mental health information, is vulnerable to attack on appeal. I do not read this proposal, however, as compelling an offender to provide information about their mental health situation against their wishes. I understand that including mental health information in the pre-sentence report is already common practice in many jurisdictions. The legal effect of Bill C-375 would serve to codify this practice and signal to sentencing judges that this information is relevant to their deliberations. Inroads are being made in recent years to eliminate the stigma around mental illness. People are more willing to talk about their struggles and their lives with a mental illness. This increased openness has led us to learn more about the scope of mental illness in Canada. The Mental Health Commission of Canada indicates that in any given year, 1 in 5 Canadians experience a mental health or addiction problem. Other statistics indicate that by the time Canadians reach 40 years of age, 1 in 2 experienced a mental illness. Additionally, we know our young people are more likely to experience mental health issues than any other group. It's well known that in the past decade, the number of individuals with mental health issues involved in the criminal justice system has increased. There's no singular reason for this increase. However, a number of causes have been cited for contributing factors. These include gaps in services for marginalized populations, including housing, income, and health services. In this regard, Mr. Speaker, I'm extremely proud to be part of a government that is making great strides in these areas. For instance, the recently announced National Housing Strategy. We also know that individuals with mental health illness are often likely to come to the attention of police and be arrested and detained. Once detained, accessing appropriate mental health services can be a challenge. Mr. Speaker, the complexities of this issue cannot all be addressed through a private member's bill, nor can the criminal code solve such a profound and complex social problem. However, I think it's fair to say that the sponsor's intent is to take one meaningful step in addressing the larger problem: the overrepresentation of the mentally ill in the criminal justice system. The bill proposes a narrow and targeted approach to ensure that in situations where a pre-sentence report is ordered, readily available mental health information is to be considered. The stated goals of the bill are consistent with the mandate given by the Prime Minister to the Minister of Justice, which asks her to address gaps in service to those with mental illness throughout the criminal justice system. Mr. Speaker, I think most Canadians would agree that the issue of mental illness could be better managed in the criminal justice system. It's an area where we must continue to work together with our provincial and territorial counterparts, as well as community stakeholders, to ensure meaningful progress is made. I want to be clear that improving the mental health responses of the criminal justice system is not about letting offenders off easy. On the contrary, it is consistent with our government's stated commitment to a criminal justice system that keeps communities safe, respects victims, and holds offenders to account. In particular, addressing mental health is one of the critical ways we can divert offenders from the so-called revolving door of incarceration, improve chances of successful reintegration, and make more efficient use of scarce resources. These outcomes, and not simply punitive measures, should drive our decision-making. As a result, Mr. Speaker, every step we take to improve outcomes for those with mental illness is a step worthy of careful consideration by parliamentarians. The proposals in this bill are also consistent with our government's other efforts to improve mental health more generally across the country. In Budget 2017, the government committed $5 billion over the next 10 years to the provinces and territories to improve access to mental health services. In addition to that, to ensure that federally sentenced offenders with mental health needs receive proper care. Budget 2017 proposed to invest $57.8 million over 5 years, starting in 2017-2018, and $13.6 million per year thereafter, to expand mental health care for all inmates in federal correctional facilities. This funding is in addition to the $69 million over 3 years announced in 2016 for immediate mental health needs, and more than $300 million provided annually to support culturally relevant mental wellness services in Indigenous communities. These significant and historic investments in frontline mental health services will benefit all Canadians, not just those who find themselves at odds with the criminal justice system. I'm encouraged by these financial commitments. It reflects the importance of investing in upstream services to ensure that people can receive help when they need it before they come into contact with the criminal justice system. I look forward to hearing the rest of this debate on this important private member's bill. Safe and healthy communities are built upon a criminal justice system that treats all Canadians with respect, dignity, and in a manner that always upholds the rights and freedoms afforded to all Canadians by the Charter of Rights and Freedoms. I'd like to thank the sponsor of this bill, the Honourable Member for Richmond Hill, for providing us an opportunity to debate this important issue facing the criminal justice system. Thank you very much, Mr. Speaker.
Resuming debate, the Honourable Member for Sturgeon River Parkland.
Thank you, Mr. Speaker. Before I begin my speech, I want to recognize and express deep gratitude to someone who is a remarkable leader, a former minister who served as a member of Parliament, my predecessor, the Honourable Rona Ambrose, who served the people of Sturgeon River Parkland with distinction, It's an honor to follow in her footsteps as the representative of Sturgeon River Parkland. I'm pleased to rise today to speak on Bill C-375, an act to amend the criminal code in regards to pre-sentencing reports. And I want to thank my honourable colleague from the member for Richmond Hill for his championing the issue of mental health in Canada. This bill would amend the criminal code to require a pre-sentencing report that contains information on a mental disorder from which an offender suffers. Canadians expect their justice system will keep them safe from high-risk individuals, and we need a policy that strikes a balance between the need to protect society from those who pose a danger and to treat those with mental illness and mental disorders with compassion. I won't be supporting this bill because I don't believe it achieves this balance between compassion for victims and their families and for the offenders who suffer from mental illness. Currently, Section 721 of the Criminal Code enables a probation officer to publish a pre-sentence report after the offender is found guilty. The purpose of this report is to assist the court in imposing a sentence or in determining whether an accused should be discharged. A pre-sentence report must contain the following information: the offender's age, maturity, character, willingness to make amends, and it also contains the history of previous dispositions under the Young Offenders Act and the history of alternative measures used to deal with the offender and the offender's response to those measures. C-375 proposes to add another requirement to this list: the consideration of any mental health disorder from which the offender suffers, as well as any mental health care programs available to them. This, in practice, will create some unfairness and inconsistencies in the application of laws and justice. Not all mental health disorders are the same. In fact, even the same mental health disorders can have a great deal of variance in how they impact the individual. And it is paramount that compassion for those suffering with mental health disorders be balanced with the need to protect public safety and provide justice for victims and their families. I also believe that these changes are concerning because they could add considerable delays to our court system that is already overburdened. Increased delays and complexity will not help those in the justice system with mental health disorders, nor will it be good for victims and their families. And I don't think any of my colleagues in this House would want trials to be unnecessarily delayed or after the fact, and I believe this legislation could add delays to our system. Our understanding of mental health continues to evolve with more research. It's an incredibly complex issue, as I mentioned before, and there is a danger when anyone attempts to address mental health too broadly. And the requirement of this bill to add pre-sentencing reports for mental disorders is too broad. As I said, not all mental health disorders are the same, and not all of them have the same relevance in our justice system. Currently, judges are able to take into account relevant information to ensure that the mentally ill are not treated poorly and that this legislation will not be cumbersome to the system. I also feel that, looking at the case in Manitoba of Vince Lee, who I believe the justice system dealt quite ably with in showing compassion to the offender, but also showing compassion for the victims and their families, it shows that the system is largely working well. And I believe that this legislation could further tip the balance too far into the favor of the accused against the victims and their families. Another danger in this change is that the broad definition could be applied to something that is very different from the sorts of illnesses that have been considered relevant in past cases. For example, it's increasingly becoming aware that hard drug addictions can be considered a mental illness. But do we really want drug addicts to be using their addictions as an excuse for committing crimes? For the law to maintain the confidence of Canadians, it must be consistently applied. Sentence exceptions for mental health disorders could create an incentive for the accused to claim that they have a mental disorder. Like all Canadians, we hope for the successful rehabilitation of those who have taken up a life of crime. Our first priority, however, must be the safety and security of Canadians and the communities where we work and live. It is well known that an increasing number of people who have become involved in the criminal justice system have mental health disorders. These individuals pose unique challenges for police, our courts, correctional facilities, and our social rights workers. In closing, I think that any justice bill must balance the right of the public to be adequately protected when those who suffer from mental illness pose a danger to society, with the rights of those suffering from the mental illnesses to be treated appropriately and with compassion. Thank you.
Resuming debate. Resuming debate, the honourable member for Mississauga Lakeshore.
Mr. Speaker, I'm pleased to join the second reading debate on Private Member's Bill C-375, an act to amend the Criminal Code pre-sentence reports. This bill seeks to address the issue of mental health, Mr. Speaker, in the criminal justice system through a targeted amendment to the Criminal Code provision governing pre-sentence reports. Specifically, the bill would clarify that a pre-sentence report should, where possible, contain information about any mental disorder from which an offender suffers, as well as any mental health care programs available to them. Mr. Speaker, I'm in full agreement with the sponsor on the fact that the issue of mental health is of great concern to the criminal justice system. It has been identified as a key concern by many criminal justice stakeholders over the years. As part of our commitment to broadly review the criminal justice system in Canada, Mr. Speaker, the Minister of Justice has indicated that addressing the needs of vulnerable offender populations in the criminal justice system is a key priority. Addressing the issue of mental health is also part of the Minister of Justice's mandate letter from the Prime Minister. Specifically, her mandate directs her to address gaps in services for those with mental illness throughout the criminal justice system. The issue of mental health has arisen numerous times so far in the course of the Minister's criminal justice review. It was raised by experts and other community stakeholders at the series of criminal justice roundtables hosted by the Minister of Justice throughout Canada over the past 2 years. This thorough consultative process, Mr. Speaker, included a total of 20 roundtables with at least one in every province and territory. Mental health professionals, as well as representatives from traditionally marginalized communities, including Indigenous and other racialized populations, featured prominently amongst the participants. The roundtable held in Vancouver in August 2016 was explicitly focused on mental health. At that event, our government heard in no uncertain terms that our criminal justice system must do a better job at responding to mental illness. Experts in the field, as well as those with first-hand criminal justice experience, explained that addressing mental health is one of the critical ways our government can reduce crime, and in doing so, create safer and more prosperous communities throughout Canada. Mr. Speaker, not only must we recognize mental health issues amongst those already involved in the criminal justice system, but by improving the mental health of our citizens before they engage in criminal behavior, we can prevent longer-term struggles which ultimately deprive our society of the full potential of those people. The idea is borne out in many of the stories and first-hand accounts that we have heard from Canadians throughout the roundtable process. A typical story, one that is all too often true in our society, Mr. Speaker, frequently begins with a young person from a marginalized community. That person will experience symptoms of mental distress, often beginning with depression or anxiety, but they will go unnoticed because of a lack of institutional capacity or social support. The young person's mental state will deteriorate, leading to lower performance at school, social withdrawal, and poor decision-making. The person's first involvement with the criminal justice system often is pursuant to a minor offense, such as a low-value theft or mischief. Nevertheless, he or she is convicted and most likely on a second offense is sentenced to a short period in custody. At this stage, Mr. Speaker, the system fails to recognize the presence of worsening mental illness. Once inside the criminal justice system, the youth is exposed to an environment which aggravates rather than treats their mental health and identifies with older, more serious offenders. Upon returning to the community, the young person now suffers from a worsening, untreated mental illness and lacks the tools to effectively reintegrate. The unfortunate reality is that this person is now far more likely to reoffend and to live a life of continued criminal behavior. Mr. Speaker, this story should not surprise any member of this House. And while it is merely an example, our experience, including that gained through our own government's consultation process, has shown that this type of scenario continues to present itself in Canadian society. It is because of stories like these that I commend the sponsor for his commitment to addressing mental health in the criminal justice system through Bill C-375. As I read the proposal, it would essentially codify the current practice of including mental health information in a pre-sentence report where that information is readily available. In my view, Mr. Speaker, this bill would not compel the offender to provide information about their mental health situation against their wishes, nor would it provide the court with the power to order the production of mental health records or empower them to order an assessment of the mental condition of the offender. Mr. Speaker, I understand that it is already common practice in many jurisdictions for the offender to provide information about their mental health to a probation officer where they feel it is beneficial to them. Therefore, in my view, the practical result of this bill would be to signal to a sentencing judge that this information is a relevant consideration at sentencing. As I was reviewing the bill, I considered how such a proposal might fit within the broader goals and mandate of the Minister of Justice. Mr. Speaker, the criminal justice system must protect all Canadians and keep our communities safe, but it must also protect the rights of all Canadians. Our government is committed to ensuring that the criminal law meets the highest standards of equity, fairness, and respect for the rule of law. Healthy and safe communities are built upon a criminal justice system that treats the individuals with whom it interacts with respect, dignity, and in a manner that always upholds the rights and freedoms afforded to all by the Charter of Rights and Freedoms, Mr. Speaker. I think such a proposal could be seen as complementing our government's broader objectives of improving access to mental health care services for all Canadians. For example, Mr. Speaker, as members of this House will know, our government made a historic investment in mental health in Budget 2017. $11 billion of federal money is being transferred to the provinces and territories over the next 10 years, almost half of which is to be dedicated to improving access to mental health and addiction services. In addition, Mr. Speaker, Budget 2017 committed $118.2 million over 5 years to improve mental health supports for First Nations and also for Inuit peoples. This money will be provided directly to communities so that they can specifically tailor programs to meet their individual needs. This funding, Mr. Speaker, is in addition to the $69 million over 3 years announced in 2016 for immediate mental health needs and the more than $300 million provided annually to support culturally relevant mental wellness services for Canada's Indigenous communities. These, Mr. Speaker, are significant and historical investments in frontline mental health services, and they will benefit all Canadians, not just those who find themselves at odds with the criminal justice system. These upstream investments in mental health services could prevent a mentally ill person from coming into contact with the criminal justice system in the first place. Investing resources in our currently saturated mental health care system could decrease the likelihood that the criminal justice system becomes the default method of dealing with these individuals, Mr. Speaker. Mr. Speaker, I would like to just briefly reflect on the communication I had with members of my own community, my riding of Mississauga Lakeshore constituents, who have repeatedly written to me on the state of, on the importance of mental health in Canada, particularly with respect to young people, with our Indigenous communities, increasingly also with our seniors. And they underscore in their correspondence to me, Mr. Speaker, the importance for the government and for all parliamentarians to take mental health seriously, to integrate mental health systematically into our policy decision-making processes, and to backstop the need to invest in mental health with adequate resources and investments, Mr. Speaker. I would like to thank the sponsor again for the step he took in introducing this bill into the House of Commons, and through his own framework, his own lens of criminal justice and its intersection with mental health needs in Canada, move the yardstick forward. Mr. Speaker, thank you again for the opportunity to discuss this important proposal, and I look forward to continued debate on this important private member's bill. Thank you, Mr. Speaker.
Avant que je reconnaisse la députée.
The Honourable Member for Avignon Métis-Matane, Matipédia. I must inform him that he has 2 minutes, and there will be more time available when the House resumes. The Honourable Member. Thank you, Mr. Speaker. I'd like to thank my colleague for his excellent speech. And as he pointed out, this bill, C-375, is an act to amend one of the paragraphs of the Criminal Code. Now, So it has to do with information on any mental issues and any problems to do with mental health. As you know, Mr. Speaker, our government recognizes that the criminal justice system has to come up with better answers, better responses to mental health issues. The government has committed $5 million over 5 years to help provinces and territories to make sure that mental health, there's more mental health treatment. So we want to review the entire criminal justice system, and this includes a complete review in order to identify the needs of those with mental health issues and in order to improve services. By recognizing the needs of offenders with these problems, we want to help to lower the rate of reoffense. These measures would help people with mental illness in the criminal justice system. According to Correctional Services Canada, more than 70% of offenders under federal responsibility and more than a half of those who are serving a federal sentence have mental issue problems. So, Mr. Speaker, you're saying I should finish? All right. Thank you, Mr. Speaker. The honourable member will have 8 minutes for his speech when the House resumes the debate on this motion. The time for private members' business is now expired and will fall to the bottom of the precedents.
Adjourned until Monday at 11 a.m. pursuant to Standing Order 24-1.